Hello everyone, and thank you all for joining us this morning for this next session of Breaking Ground. I can see that some people are still logging on, so we'll just give it another minute or two before we start. Whilst you're waiting, if you'd like to connect with any of today's presenters on LinkedIn, you can do this by using the QR code which is on your screens now. I should also point out whilst we wait that this session is being recorded, and whilst you can see us, we cannot see you. Okay, so it looks as though the numbers joining are leveling off now, so let's make a start. My name is Laura Johnson, and I'm a Principal Associate specialising in construction and engineering risks within our insurance disputes practice. I'm joined today by my colleagues Adrian Kwintner and Alannah Williams, both of whom also specialise in construction and engineering claims. Morning, both.
Good morning.
Morning.
So today we're discussing the Preaction protocol for construction and engineering claims. In this session, we'll be focusing on the initial steps to be taken. In particular, we'll have a look at the purpose and scope of the protocol, acknowledging receipt of the letter of claim, and preparation of the letter of response. We'll finish up by having a quick look at the pre-action meeting. At the end of the session, we'll be considering a couple of hypothetical case studies arising from typical construction claims to apply some of what we'll be discussing today to a practical scenario. So Alannah, let's start with you. I think just to kick things off, it would be helpful if you could first explain what exactly is the Preaction protocol.
Sure. Well, the protocol applies to all construction and engineering disputes. This includes professional negligence claims against architects, engineers, and quantity surveyors. The protocol governs parties' conduct pre-action, so before anyone has issued court proceedings. And the objective of the protocol is twofold. First, the purpose is to encourage early exchange of information at the pre-action stage, so the parties broadly understand each other's case and can make informed decisions about settlement. The hope is to avoid the need for litigation. Second, if litigation cannot be avoided and proceedings are issued, the hope is that the parties will have complied with the protocol and that this will help proceedings to proceed more efficiently and cost effectively.
Great, but Alannah, you said there that the protocol applies to all construction and engineering disputes. Are there any exceptions to this?
I'll take that point. Yes, there are a number of exceptions to the requirement to comply with the protocol. For example, if the claimant is seeking to enforce an adjudicator's decision, or where the claim is for an interim injunction, the parties won't need to comply. Other exceptions are on this slide. This isn't an exhaustive list, and there may be other good reasons not to comply with the protocol, such as where limitation is about to expire, or where the parties' contract imposes strict time limits, which would make compliance with the protocol impractical. Looking at all of the possible exceptions would require a separate session, but the key point is that non-compliance is the exception rather than the rule, and a party should think carefully before deciding not to comply.
In reality though, Adrian, what happens if a party just doesn't comply?
If a party missed a protocol deadline by a few days, there's unlikely to be any consequence. However, in more extreme cases of non-compliance, the court could be persuaded to make adverse cost orders against the non-compliant party or stay the proceedings until the protocol has been followed. It's common to miss deadlines under the protocol, and very often cases are settled before the case gets to trial, usually with no consequence at all. However, parties should be mindful of the court's power to decide what constitutes serious non-compliance and to impose consequences for non-compliance.
Great, both. Now, that's been a really interesting overview of the protocol, but I think it would also be helpful to look at some of the practicalities. So what's the first step that a defendant needs to take from a practical perspective?
So, Laura, we're putting up a slide which shows the steps provided for by the protocol. You'll see that the first step for the defendant is triggered by receipt of a letter of claim. At that point, the defendant is required to acknowledge receipt of the letter within 14 calendar days. This is usually just done by sending a short email. If the defendant doesn't acknowledge receipt within that 14-day time frame, the claimant is free to issue proceedings at that point without any further compliance with the protocol. Also, it's not often used, but there is a protocol referee procedure available if one party considers that the other has failed to comply with the protocol. This is a consensual procedure, not a compulsory one, which provides access to an independent solicitor or barrister who will make a decision on the alleged non-compliance and then issue directions about the steps the defaulting party needs to take.
Excellent. And so for the purposes of today, I'm going to assume that the letter of claim is acknowledged. If so, what happens?
So once the defendant has acknowledged receipt of the letter of claim, it's required to send a letter of response. The deadline for this is 28 days from the date of receipt of the letter of claim, rather than from the date of acknowledgement.
And Alannah, what does that letter have to include?
There's no prescribed content or format per se, other than that the letter of response is to include a brief and proportionate summary of the defendant's response to the claim or claims. Also, if the defendant wants to make a counterclaim against the claimant, the defendant can include that in the letter of response and should set out a brief summary of the claim and its basis, what the relief is, and if they're claiming a monetary sum, the defendant should also provide a breakdown of that sum.
Now, I note that you mentioned there that the letter of response should include a brief and proportionate response. What does that mean? What should that entail?
Well, the key point is really just that pre-action letters aren't meant to set out all of the details of the case or the full story of what happened blow by blow. The idea is that the parties avoid incurring disproportionate costs preparing or responding to letters at the pre-action stage. However, the defendant should identify in its letter of response any key documents, for example, the contract, letter of appointment, and key correspondence, and include copies of these with its letter. Generally, it's not expected or required that the parties provide expert reports at this stage. That said, if the defendant has obtained an expert report and the report is succinct and central to the claim, providing a copy of the report with its letter of response can be a helpful way of explaining the defendant's position.
Now, there must be numerous situations where the defendant doesn't agree with the claimant's estimate of its loss to the sum claimed. What happens in that scenario?
Well, that's often the case, and practically speaking, in that situation, the defendant should say what they estimate the claimant's loss to be. If this isn't possible at the time of sending the letter of response, the defendant should say why they can't provide an estimate now and when they expect to be able to do so.
Okay, so we've served a letter of response, and we may even have included a counterclaim. What happens next?
The next step is for the parties to meet on a without prejudice basis. This should happen within 21 days after the claimant receives the letter of response, or if the letter includes a counterclaim, 21 days after the claimant's response to that counterclaim. There are 4 general objectives for the parties at the meeting. The first is to identify the main issues in the case. Next is to identify the root cause of disagreement on each issue. Thirdly, to consider whether the dispute might be resolved without litigation, and if so, how. And finally, if litigation is unavoidable, the parties should agree what steps are needed to ensure the proceedings are dealt with by the court justly and at proportionate cost in accordance with the overriding objective.
So, Adrian, is there a particular format prescribed for this meeting?
Well, not really. The protocol requires the parties to attempt to resolve the matter or the issues in dispute and consider using ADR, alternative dispute resolution, to do so. If the parties agree ADR would be useful at this early stage, the pre-action meeting can be run as a mediation or other form of ADR, such as arbitration. what we find is that ADR is more likely at this early stage on lower value, less complex claims where the parties already have a fairly good understanding of the issues. It's important to note that the parties can't be forced to enter into ADR, and the protocol doesn't dictate a format for the meeting other than it must be without prejudice. So other than that, the parties decide how to run the meeting.
Now, you said there, Adrian, that one of the objectives of the meeting is to consider resolving the dispute. But what happens if a resolution can't be reached?
Perhaps I can answer that, Laura. So this is actually fairly commonplace. If the parties can't resolve the dispute at the meeting, the parties can still use it to bottom out future steps. So the protocol provides that if the parties can't agree a settlement, they should use the pre-action meeting to try to agree things like the extent of the documents to be disclosed with a view to managing cost, what expert evidence is required and how it will be dealt with, whether the parties should appoint a joint expert, and if so, who, and how the litigation should be run to minimise cost and delay.
Great, so we've discussed there the objectives and format of the meeting. Turning now to attendees, who would you expect to attend the pre-action meeting?
That really largely depends on the nature of the parties. So if the party is an individual, that individual should attend the meeting. Where the party is a company, it is important that a representative of the company who has authority to settle or to recommend settlement of the dispute attends. If the parties have instructed lawyers, those lawyers should attend the meeting. And if the defendant hasn't disclosed the involvement of its insurer, a representative from that insurance company or the insurer's legal representative should also attend.
Thanks, Alannah. Now, what I'd be interested to hear, though, is whether the parties have to attend this meeting in reality. Is it obligatory?
That's a really good question. There are many scenarios where it's appropriate not to have a meeting. The Technology and Construction Court Guide, also known as the TCC Guide, says the meeting isn't mandatory if it would involve disproportionate time and cost, or it's clear the meeting is unlikely to serve a useful purpose, or the claim is brought by a litigant outside the UK. So, for example, it may be sensible to dispense with a meeting in lower value claims, or if the defendant has served a letter of response blankly denying the claim without providing any details. Each case will depend on its particular facts. However, it's important to note that although the meeting is without prejudice, the parties may be required to inform the court whether it took place, if not, why not, and which party refused to attend and the reasons for their refusal. There have been cases where the courts imposed cost sanctions on a party who refused to attend a meeting. In some cases, the court has even awarded indemnity costs, which means the party who refused to attend must pay a higher cost contribution to the other party than is standard. So it's something that does need to be taken seriously.
Yes, I can see that, Adrian. And so I'm going to assume that the meeting goes ahead. What happens afterwards? What's the next step?
Well, if the parties have met, the protocol process is meant to conclude after the meeting. If no meeting takes place, the protocol process is meant to conclude 14 days after the meeting should have taken place. But in practice, the parties might continue to engage without starting court proceedings, and we often see that happen. But the protocol does aim to avoid protracted exchanges.
Well, thank you very much for that. Thanks, both of you. That was a really helpful run through of the protocol. And there was some really interesting stuff in there, but I think that it would be helpful now to take a look at one or two case studies to illustrate all of this in practice. There will be a poll at the end of these scenarios. So, as you should be able to see from the slide on your screen, in our first scenario, the defendant and the claimants owned adjoining properties in London. The defendant began to undertake some excavation work at his property. The claimants weren't happy with this because the work backed onto their property. and they therefore served 4 letters of claim on the defendant, making various allegations about the work. There was absolutely no response from the defendant. The claimants therefore issued proceedings seeking an injunction. In response, the defendant served a defence and conceded some of the other issues raised by the claimants. The claimants therefore served a notice of discontinuance but applied for their costs. Now, as many of you will know, that's interesting because ordinarily, where a claimant discontinues, the default position is that the defendant will recover costs. However, in this case, the claimant cited the defendant's unreasonable pre-action conduct as good reason for departing from the position. Now, this case went all the way to the Court of Appeal. On the screen, you will see a number of statements. And what we'd like you to do is choose which one you think best describes the outcome of the Court of Appeal hearing. So we'll just give you a few moments to select your answer, and then we'll take a look at the results. So the statements are: A, the claimant's claim for costs was rejected and they were ordered to pay the defendant's costs in the usual way. B, the defendant was ordered to pay the claimant's costs. Or C, there was no order as to costs. Now, I can see that most of you have been selecting your answers whilst we've been talking, and it looks as though many of you have gone for A. Alannah, can you please tell me the answer?
The answer is in fact B. So the Court of Appeal held that the defendant had shown no willingness to set out his position, to narrow the issues in dispute, to discuss mediation, or to try to reach a settlement. Consequently, the court did order the defendant to pay the claimant's costs up to the date of service of the defence, although there was no order for costs after that point. So this case demonstrates the importance of complying with the protocol unless there is a very good reason not to do so. As we mentioned earlier, minor delays in serving letters or attending the meeting are unlikely to result in any real consequences. However, what this decision shows is that the courts are willing to impose cost consequences in some cases where a party has failed to comply with the protocol. It is ultimately a matter for the court to determine the seriousness of the non-compliance and the consequences that flowed from that failure to comply. The upshot is that it would be risky for any party to a dispute to simply assume that compliance with the protocol is optional.
Thanks for that, Alannah. So let's move on now to the next scenario. This case concerns a block of flats which the claimant had built on the Isle of Wight. The claimant subsequently served a letter of claim on the defendant architect, alleging that he'd been negligent. The defendant served a letter of response which contained an outright denial of liability. The claimant therefore issued proceedings without engaging in a pre-action meeting. The defendant applied to the court for a stay of the proceedings pending a pre-action meeting taking place. Now, once that application had been issued, the claimant offered to agree to the stay, provided that the meeting took place within 6 weeks. And if it were to be unsuccessful, that the defendant would serve the defence within 4 weeks of the meeting. However, the defendant refused to agree to this unless the claimant would also pay his costs in respect of the alleged breach of the protocol. So again, on your screen, you'll see a number of statements, and we'd like you to pick which statement you think best describes the outcome of the defendant's application. So again, we'll just give you a few moments to have a look, and then we'll discuss the answer. So A is that the court refused the application and ordered the defendant to pay the claimant's costs. B, the court granted the application and ordered a stay of proceedings. Or C, the court refused the application, but given the claimant's failure to engage in a pre-action meeting, it made no order as to costs. So again, I can see that most of you have been submitting your answers whilst I was talking. And it looks as though the majority of you in this case have gone for C. Adrian, can you tell me what the answer is?
Well, Laura, it's actually A. The court noted that the protocol did not say that a meeting was absolutely mandatory. The default position is essentially that a meeting should take place unless there's a reasonably good reason for it not to. It was incumbent on both parties to try to arrange a meeting. It was not surprising that the claimant thought a meeting would probably be pointless given the defendant's absolute and uncompromising rejection of the claim in the letter of response. The defendant could have suggested a meeting before proceedings were issued, but chose not to. So the court held it was reasonable for the claimant to have issued proceedings without a meeting beforehand. The claimant offered to stay the proceedings for the purpose of a meeting, but the defendant rejected this unless the claimant agreed to essentially pay his costs up to that point. The court held that the defendant's approach was unnecessarily confrontational and his application was disproportionate to the size of the claim. What both of these cases show is that any non-compliance with the protocol will be determined on its own facts. Generally, the courts will try to take a pragmatic approach when considering what is reasonable pre-action conduct, and will always have proportionality in mind. However, as we saw in the first case, the court isn't afraid to impose harsh consequences in cases of unreasonable conduct.
Thanks for that, Adrian. And yes, I entirely agree with the conclusions that you reached there. Well, everyone, that's all we have time for today. And thank you for joining us this morning for this session. Please do complete the feedback form, which will be on your screens when we sign off. And feel free to include within that feedback any topics that you'd like us to consider speaking about in future sessions. And remember to connect with us on LinkedIn if you wish to do so. Also remember, if you'd like us to provide you with a more detailed answer to any of the subjects we touched upon this morning, or if you'd like some more practical input, please let us know and we can communicate with you directly by email. We wish you a good rest of the day.